You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome, listeners, to another episode of People, Places, Planet. I'm your host, Dara Albrecht, and our episode today is going to center on a book that's the fifth in a series by the Environmental Law Collaborative, titled Adapting to High-Level Warming, Law, Governance, and Equity. In seeking and analyzing climate solutions, most legal scholarship assumes a 2 degrees Celsius warming as the upper bound of temperature change. But robust science increasingly tells us a different story. Warming beyond 2 degrees is likely, and warming as high as 3 to 4 degrees Celsius by the end of the 21st century is a real possibility. This book takes up the challenge of thinking about law, governance, equity, and justice in a future shaped by high levels of warming. It begins by identifying and offering solutions to address the mismatch between today's legal and regulatory systems and the conditions and demands of high-level warming. We're here to spotlight 2 chapters in particular: Climate Change Communities, written by Professor Sarah Fox, and Preemption, Opportunities and Obstacles for Climate Adaptations by Professor Kevin Lynch. Both authors are here with us today. Editors Katie Q and Shannon Roesler will also contribute throughout this episode to share details about the editing process and other thinking on the important ideas brought up in this book. So, to our 4 wonderful guests, thanks for joining me on the podcast today.
Thank you so much for having us.
Absolutely. So, let's turn to our first question. Katie and Shannon, how did the creation of this book come about? You had to tie all of these folks' expertise together, secure authors, and find ideas where they could write chapters that would then fit an overall cohesive narrative.
The origin story for the book really starts with 4 individuals. So first with Professors Jesse Alley and Keith Hirakawa, who formed the Environmental Law Collaborative, which works in a very different way than most kind of academic scholarship is produced. It brings together environmental law professors every 2 years. And instead of coming and presenting work that we have independently researched, the Environmental Law Collaborative identifies an emerging challenge in environmental law and policy and invites everyone to come together and spend 2 days thinking and talking about it. Then we all go our separate ways and write about it. This book is a product of our 5th meeting, which was held in Colorado in summer of 2021. The 2 other individuals are Robin Craig and J.B. Rule. Shortly before our meeting, they had authored a law review paper titled 4C. It was published in the Minnesota Law Review. We organized our Environmental Law Collaborative meeting thinking about adapting to high-level warming, inspired by the paper that Professors Craig and Rule had authored, where they pointed out that central insight that most adaptation planning in the United States assumes that we will keep warming to 1.5 to 2 degrees, when it now seems quite clear that we won't. And it also seems quite clear it would be very imprudent to assume that we would.
It is a joy to be part of this group because of how we approach these topics. So that means we didn't go looking for authors in the way you might think editors of a volume would do. This happened organically. People went out and they wrote about what they see the emerging issues really are. And then Katie and I brought our editorial lens to how we thought they might go together.
Thanks for explaining more about that editorial process, Professor Roesler. Professor Q, to go back to your point, you mentioned that there's often this focus on warming to 1.5 or 2 degrees Celsius, and that increasingly it's becoming obvious that it might be short-sighted just to look to that extent of warming. One sentence of the book description that particularly impacted me was, "Many of the ideas proposed in this book may sound wildly ambitious today, but will ultimately appear modest when weighed against the tolls of a superheated climate." I'm curious what this book might add to the field in terms of people sort of thinking beyond that 1.5 or 2 degrees Celsius and seriously considering the range of extreme possibilities when it comes to a heated world.
I think in that regard, we're only starting to appreciate that high-level warming is not just extreme on the ground. It's going to require extreme changes in the status quo with respect to everything from our laws and regulatory systems, our governance, and how we think about possibilities for trying to preserve as much equity and justice as we can. And to give you a sense of when you quote that blurb in the book about things that might seem kind of wildly aspirational or unusual to talk about that now, I might point you to the chapter in the book authored by Professor Xu that talks about the creation of a resources trust that essentially predicts under high-level warming, we will periodically have extreme or dislocating shortages of basic goods in the United States. And we should essentially have a government program for putting survival material aside and a way to push it out when that need arises. Or Professor Craig's chapter, where she talks about, in some sense, we might need to think about adapting to high-level warming as akin to medical triage, where we know you can't save everyone and everything. And how do you think about prioritizing and your resources, thinking about what you can and can't do and making those hard choices?
That's super interesting, and I think really important points to consider as we think about the range of possibilities that the future holds. So, we're highlighting 2 chapters from the book today. I briefly mentioned them in the introduction, and both of these chapters fall under the Governance in a Warming World section. Could you tell us a little bit about these chapters, and how do these pieces fit into the overall flow and theme of the book?
Well, I might start by providing just a bit of background. When we received drafts from our authors, Katie and I asked, are they falling into different groups? To some extent, I think Katie would agree these sections in the book are a bit artificial. There's a lot of overlap. But we notice 3 big themes. Some authors are really focusing on a set of laws or institutions, for example, Western water rights in the first chapter of the book, and how high-level warming would interact with those legal systems in place. And a lot of people talking about governance issues of federal, state, local regulation and how different scales of governance interact. And a lot of people writing about equity and justice and how high-level warming will disproportionately impact the most vulnerable populations. The 2 chapters you're highlighting fall in that governance section because they talk about responses at the local and state level and the interaction of local and state governments to some extent. They work really well together because they're really focused on how local and state governments can adapt to high-level warming. For example, local governments, they are creatures of the state, right? So they are constrained by state law. But that's not the whole story. Sarah's chapter does an excellent job talking about how local governments can respond with the tools they do have to high-level warming.
Yeah, I would love to hear more about it. Sarah, could you tell us about your chapter? How did you get the idea to write about climate change communities, and how does it relate to your current or prior work outside of writing this chapter?
I think the prompt 4 degree C is such a powerful call to consider, realistically, what is high levels of warming or what are high levels of warming going to look like? And to take that really critically, but also in a very concrete way. And so I do a lot of work on local governance, on local institutions. And I wanted to take the opportunity to think about, all right, let's take this seriously. Let's think about what happens if there actually are high degrees of warming. That is going to impact local governance. And I think Shannon was alluding to this a bit. Local governments might not be the best suited to do climate policy, right? But they are absolutely going to feel the impacts of climate change and high levels of warming. And so I wanted to take that opportunity to think about how is that likely to impact different types of local governments? What are the different local mechanisms that we need to be thinking about? And for me, part of the call to do that is just the impetus to do something, right? That we can't necessarily prevent all of this warming that we expect to happen, but we can control how we're responding to that. And so thinking more critically about what that looks like at the local level was important to me.
Yeah, that's very interesting. And to delve deeper into the content of your chapter, I'd like to start out by asking you, what exactly is a climate changed community? And do they already exist?
Yes, they absolutely already exist. And, I don't have a perfect definition of a climate change community other than it is a community that is impacted in various ways by climate change. Certainly, some communities are going to be impacted in different ways than others, but we can look to Los Angeles has been on everybody's mind lately with the wildfires that we saw devastating large parts of that city. There's plenty of science, right, supporting that those wildfires and the risk of those wildfires are linked to climate change and to overall changes that have been happening in that region. That's going to change that community and region as they start to reconsider what that community looks like when it comes to planning for the future. If you want to look even more extreme, there are Gulf communities and communities in Alaska. And I'll focus on Alaska in particular because some coastal communities in Alaska have already literally had to move their communities because of the thawing permafrost. They're no longer able to have the physical structure of their communities. Newtok, Alaska is one example, that it has to move further inland because literally the ground that their community is built on can no longer support those community structures. We see this to a certainly less dramatic degree, but I'm based in the upper Midwest, and we've seen the level of ice on the lakes in the winter has been greatly decreased over the last couple of decades, such that communities that used to rely on tourism in the winter for things like ice fishing are no longer able to do that. And so that's impacting conversations about the livelihood of people in that area and what that looks like going forward, as we can no longer realistically expect, right? This is not just a blip. Even for those who are not heavily immersed in climate science, that this is not something that we can expect to return. And so I think it impacts communities in all of these different ways. There's increased drinking water issues, there's increased heat stress issues. I think all of those are climate changed communities. And that's why I kind of use the broad term, because I think it behooves every community to think about what does climate change mean for this particular community.
Definitely, especially since the impacts can be so different depending on where you are. One quick follow-up question. Does the size of the community at all factor into what counts as a climate change community for you? Or can we just think about it as community on a local scale?
I think it more from a governance perspective. So what are the governance structures for this community? I think Michelle Oko's chapter in the book does a great job of diving into more theoretical questions of what makes up a community. How do we think about that outside of this kind of governance perspective? What makes sense from an equity perspective? And I'm really taking it on the what are the local governance structures here that can help make these necessary planning changes for the community? And so in that sense, I don't think it matters if it's a mega city or if it's a tiny village, right? There's governance structures that we can do in both of those cases.
I might jump in and suggest the fact that we started talking about the ideas in this book in 2021, and we're now here in 2025 and reflecting on the past 4 years. I think you can look back at what's happened on the ground in the United States in the past 4 years and credibly argue that we all live climate changed lives and we all now live in climate changed communities. But I think a second observation, and this struck me reading, actually, I think both Sarah's chapter and Kevin's chapter make reference to climate havens. So locations that have been viewed as largely insulated from or safer with respect to climate impacts. I think another insight reflecting on the last 4 years in terms of what we've seen on the ground with respect to climate impacts is that we have perhaps had too much hubris about our ability to predict and understand how climate change will manifest in individual locations. And the example that I would give of that is Asheville, North Carolina, which had been recognized by many and actually, I think, marketed as, hey, this is a climate haven. This is a safe place to come if you're worried about the impacts of climate change, and then seeing the absolute devastation after Hurricane Helene in Asheville, North Carolina, I think should make us all pause and understand that first, we all live in climate changed communities now, and also that we really have very little ability to reliably predict and understand the extent to which they'll change and how they will change, especially when we start moving into higher levels of warming.
Thanks for the additional insight, Professor Q. I think it's really important to consider those things. And that leads perfectly into my next question, which is that one general idea that I saw come up in the chapter is that adaptation will require recognizing that a changing climate will bring winners and losers, which obviously on the surface seems like a very binary way to view all the outcomes that can come as a result of a changing climate on communities. What is helpful about recognizing and understanding these effects from that perspective?
Yeah, well, with the giant caveat that Katie is, of course, correct, that we don't have perfect information or ability to predict exactly where those winners and losers will be, and probably there's going to be a huge amount of variability. I still think it's useful because one thing that comes up for me repeatedly in work on local governments is you have to understand the particulars of the place before you can really dive into anything that's useful for that community. And so it's important just to say, climate change is not going to impact every community in exactly the same way. There are maybe ways that you could lean into the warmer temperatures. There are certainly people in the upper Midwest that are not that sad about the fact that it's going to be slightly less cold, and farmers in particular about the fact that maybe there's slightly longer growing seasons, maybe there's some opportunities. Conversely, I think it behooves many communities who might be on what we call, quote unquote, the losing end here to think really hard about what that means for the future of their community. And so framing it as winners and losers is not kind of awarding, a gold star to certain communities because they've done something right versus, deducting points from another. They didn't do anything necessarily put them in that situation, but there are better and worse things that you can do going forward to account for how those climate impacts are likely to play out. So that's one reason. It's just kind of emphasis on that change overall and the fact that you need to look at the particulars of place. But I think it also is useful in that it helps us with planning. And I think that's a big theme of my chapter, that we have to just account for what we can reasonably expect to see, which is higher levels of warming than we have been planning for. And so if we can think about this in terms of where, again, we're going to see these worse impacts or arguably lesser impacts from climate change, well, then maybe we can use the planning process to encourage different patterns of population growth. And that could be at kind of a micro level in terms of which neighborhoods are going to flood most likely, right? Under these kind of higher models of warming. Why are we still allowing, buildings to be constructed in this floodplain where we know there is going to be flooding going forward? Or at a more macro level, how within a state do we encourage better population patterns, or even on a regional or national level, to kind of account for where we see those winners, quote unquote, or losing communities happening? And I think part of that is also just tied into people have to live somewhere. There are going to be parts of the United States, in some regions, large parts, that are not going to be as habitable as they once were. And so if we can take this seriously and think about where, again, the kind of winners or losers, or at least the more habitable and less habitable parts of the United States are going to be, we can maybe acknowledge that there are probably better and worse places to be. Even if all communities are going to be impacted, even if we don't have perfect information, we have some information to tell us where it's likely to be slightly better or slightly worse in terms of these high levels of warming.
Definitely. And as you were saying that, I had one more thought, that there maybe is one more benefit. A lot of local communities or the average person may not understand a 70% probability of X increase in flooding in whatever amount of time, but people do generally understand the concept of being a winner versus being a loser. And obviously, people don't want to be climate losers. So I think putting it in those simple terms and saying, okay, if you want to be a climate winner, these are the actions that you would take. And if you are to be a climate loser, then maybe you wouldn't take these actions, or you would take these other actions. And then it's easily understandable by everyone.
Yeah, that's interesting. I think you are more assigning the kind of gold star system than I was in the chapter in terms of here are the good things to do versus not. But I think you're right. Maybe that fits into a model of what should we be doing, right? What are the right actions to take? It certainly fits into our national rhetoric right now of losers and winners.
If I might jump in, it's maybe a sentence in Sarah's chapter, but it does come up in other chapters. And I'm listening to her talk about how it comes up for local communities, but it's really kind of at the heart of Rob and Craig's chapter on triage, right? And Shiling's chapter on resource trust. So there will be, in a sense, winners and losers. These are all equity issues when we have to make hard decisions about our resources. So the section of the book that focuses on equity and justice takes this on in slightly a different way.
Professor Fox, you also mentioned that as our communities change, we're going to have to more closely examine what actually makes our communities communities. Can you expand more on that idea?
Yeah, the prompt on reconsidering what makes communities communities was my attempt to prompt some of these hard conversations about what are we willing to give up, right? In a world where, as Professor Craig's chapter mentions, you can't necessarily save everything. What are the fundamental things about your city or your village or your neighborhood, whatever that kind of governance unit that we're talking about may be, that are really important and that are important to you to carry forward? And so the way that I see this coming up in terms of climate change communities is, are we expecting our population to grow or to shrink? Are we looking at having an influx of new people coming into this community? And if so, what does that mean for us? How do we protect people in the sense of avoiding certain gentrification pressures or other kind of increases in housing prices that might result from a lot of newcomers to the community? How do we avoid prejudicial treatment of those newcomers that we know often happens when we have a flood of new entrants to a community? How do we think about that? How do we retain the unique nature of the community we're talking about while also acknowledging that we're going to be growing in this way or can expect to grow in this way, or even frankly have the opportunity to grow in this way, right? Seeing this as kind of a way to bolster a community that's already there. On the other hand, if we're in a community that we can reasonably expect is going to lose population, whether significantly or even moderately over the next several decades, what does that mean in terms of retaining, again, a shared set of values, which Professor O's chapter talks more about? What does that mean in terms of, frankly, how do we hold this community together, if at all? How do we shrink a community in terms of, overall actual physical footprint of the city? Are there places that we should be downzoning and should be really trying to consolidate our growth into a much smaller area of the city, maybe an area that's expected to experience less dramatic changes from climate change? And again, just taking on this question of what do we want this to look like 50 years out, 100 years out? How do we change that kind of planning forecast?
I think Sarah mentioned it, but I think the chapter that precedes Sarah's chapter, America Erased, really is a deep contemplation about what does community mean when you have high-level warming, and particularly when you're in a situation where your community can no longer physically remain in the same geographic location. So Professor Michelle Coe uses Princeville, North Carolina as a case study for this. And Princeville, North Carolina is the first city founded by freed slaves and flooded after both Hurricanes Floyd and Matthew, and is now considering at least partial relocation of the city. And she takes a close look at our current historic preservation law and surfaces the fact that a lot of it is very much focused on in situ preservation in place and what happens when you lose geographic place, and is there a way to maintain community without that geographic grounding? And she suggests the possibility of relocating communities to the metaverse and highlights that at least one low-lying island state, Tuvalu, has already done so. They have mapped and recreated Tuvalu in the metaverse in an effort to retain some sense of that geographic place that they know will ultimately be gone.
I didn't even know that could even be possible. It's a very sobering thought, but it's also important, I guess, to think about how new tools we have at our disposal can help communities retain some sense of what things were like. So I'm definitely going to read more about that chapter later. Sarah, if they're not already climate change communities, how can local governments prepare to become climate change communities?
Yeah, I mean, it depends, right? It depends on what the expected changes are likely to be. I think at a high level, all local governments should be looking at, do our governance structures that we currently have in place make sense, right? And so I highlight several examples in the chapter of several parts of the country, including areas of kind of the Pacific Northwest, as well as in Florida, where we see maybe some early kind of regional governance structures emerging that we did not previously have to help kind of coordinate responses to the warming trends and the overall climate change trends that we are seeing, sharing information, sharing resources, allowing for kind of greater partnerships in terms of maybe some of that sharing of resources. And so I think that some of that is going to be necessary and is a good idea for local governments across the United States to think about setting aside the authority to do that. And so that's going to vary widely. That's kind of the piece that I know Kevin is going to talk more about, right? This kind of how do local governments get the authority to do that? But assuming authority to collaborate regionally, I think that makes a lot of sense. Funding structures are going to be a huge part of this for local governments as well. And so, for instance, if we're talking about local governments that may be looking at losing a lot of their population, that can have a lot of impacts overall in terms of sense of community, in terms of whether or not businesses want to locate there. But it also has a huge financial impact for these local governments as well. Most local governments in the United States get a lot of their money from property tax revenues. And so it's very easy, as you have people leaving a community, even if it occurs more gradually over time, to really drastically shift the kind of financial prospects and realities of a community, which, climate change or no climate change is a phenomenon that can kind of result in this kind of spiral for a community where they're having to increase tax rates, and then that's driving more people out. And I think that's just a known reality of local finances, but it's worth thinking really critically well into the future to see, is that expected to happen? I think there has to be a resetting of expectations around state and local finance, frankly, across the United States in terms of how local governments are being funded to really account for this, right? The population patterns are going to shift, and just expecting things to remain either stable or in a constant growth mindset is just not realistic and is not going to serve those communities well. And so I think that funding conversation is a longer term conversation, but that's why it's important to start now before we kind of get into the really high level warming that we're likely to see down the road. I think changing overall planning expectations in really all states, there is some requirement of planning at the local level in terms of planning for the community, planning for land use is pretty highly variable in terms of, first of all, whether that's actually enforced, and second of all, whether that is just assumed to take the form of zoning or whether there are other more comprehensive planning requirements in place. But I do think that kind of comprehensive planning is really necessary, whether frankly required by the state or not. And taking it not just oftentimes it's on a 15-year, 20-year timeline, really expanding that out is going to make, I think, a bigger difference as well to incorporate the science that we have and to take a really realistic look at what the community is expected to be like. I think that can be helpful, not only, of course, in getting the planning outcomes that make sense based on the science, but also in terms of messaging to community members and saying, look, when we take our planning horizon out a little bit, this is what we see. And this is why we're taking certain actions now. Right? You've got to have that overall narrative, I think, to sell people on the idea of change, because people don't like change, right? Everybody, or most people, would like things to remain relatively the way that they are. There's always room for improvements in various ways, but you start telling many people that their community is going to look drastically different, and that's not going to meet with a positive reception, and it's hard to make the necessary changes there. What local government should be doing is going to depend a lot on whether you expect to have an influx of people versus an outflow of people. For local governments that think that they are likely to be a receiver city, right, a climate haven, Professors Furlan and Hirakawa do a nice job of defining these phrases in terms of climate havens, right, being places that actively are trying to attract people versus kind of receiver cities that are going to get people but might not be as enthusiastic about it. In either case, there needs to be planning to accommodate these new entrants in terms of maybe we need to change zoning laws to allow for more housing to be built. If we expect more housing to be needed, now would be a good time to start thinking about that rather than when those housing pressures get so great down the road. For cities that have kind of marketed themselves as climate havens, I think there's been a lot of fair critiques of the fact that those cities have not done a lot of actual on-the-ground planning to account for the people that they are actively trying to attract. And so what does that look like? I think at a really granular level, cities need to be taking on as well. And for those that are expecting an outflow, the financial piece of it is huge, but also downzoning, right? Thinking about what does this physical footprint need to look like to keep some coherent sense of community so you don't just end up with kind of scattered patches and depopulated areas in the way that we've seen in some Rust Belt cities, for instance, that has not been overall good for their population.
Thanks, Sarah. I think you did a great job at illustrating all the moving pieces that governments have to consider in order to plan to become climate change communities. Or even if they're not climate change communities, like you said, climate haven or receiver cities might not necessarily be climate change communities, but then in a way they are, because everyone's having to feel these impacts. So, Katie and Shannon, this chapter comes right after Michelle Oko's America Erased chapter, where she discusses the cultural impacts that climate change might have on the U.S. In threading together the chapter order, can you tell me a little bit more about what made both of these chapters compelling to put next to each other and how their ideas might work together in the flow of the book?
Dara, I remember very distinctly thinking about trying to organize the chapters, and I thought that situating Michelle's and Sarah's chapters together worked really, really well for two reasons. The first we've already talked about is that both are contemplations about how high-level warming will change communities in place and how the law should respond. But you'll see that Michelle's chapter, America Erased, is the last chapter in the section of the book focused on laws and regulatory systems. And Sarah's chapter is the first chapter in the section of the book that's focused more broadly on governance. And even though both authors were looking at the general issue of how high-level warming would impact communities, local governments in place, Michelle's chapter made recommendations specifically focused on a particular statute, our historic preservation law in the United States. And her critique of that statute is that it doesn't really fit well with high-level warming because it is so focused on preserving cultural resources in situ in the places where they currently are, when that may not be possible in the face of high-level warming. Whereas Sarah's chapter, confronting the same general issue, takes a more governance-centered lens to think about what is the relative responsibility and capacity of local governments versus state governments versus federal governments in thinking about how we prepare our communities to deal with high-level warming. So confronting the same issue, but doing it through different lenses, with Michelle's chapter more focused on a specific statute and reforms discussing a specific statute of federal historic preservation law, and Sarah's chapter thinking more broadly about environmental federalism. Which level of government is best suited to have what type of authority to best address this problem? So I thought they were really nicely situated next to each other and helped the book transition from the two different sections.
Thank you. Yeah, it's great to hear your thoughts on the overall flow. And now, as we move forward to Kevin's chapter, Kevin, what connection do you observe between the climate change communities chapter, bringing up all of these important considerations about local governance and how local governments can prepare to deal with climate impact, and your chapter, which is focused on preemption?
Yeah, so I think Sarah's chapter and the idea of climate change communities really underlies exactly what I'm getting at in my chapter on preemption. So she laid out all the ways communities will need to plan and adapt, in particular, planning for growth or planning for loss, or maybe planning for both at the same time. And there's many tools, as Sarah lays out in her chapter, that local governments can use to make those planning decisions and to adapt. And preemption is just one of those. But preemption to me, and the reason I focused on this is because preemption is a key way to resolve conflicts that might arise in these areas. So there may be breakdowns in cooperation between local governments, or perhaps local governments are taking actions that are contrary to critical climate adaptation measures that we might need on a regional, state, or even national level. And so the availability of preemption as a legal tool is really critically important to resolve some of those conflicts. And I will just add one other thing. Professor Fox is really one of the leading experts in this country on the topic of preemption. She was one of the co-authors on the National League of Cities report that I discuss in my chapter. So I really also benefited from her input as I was thinking about and drafting my chapter on preemption.
Thank you. And on that note, maybe you and Professor Fox could tell us a little bit about the chapter. I'd love if we could start off on a quick background or recap on preemption, just for our listeners.
Sure. So the legal doctrine of preemption was really designed to help resolve conflicts between regulations at the state and local level. And I'm really focusing on state level preemption, but of course, there's a similar dynamic at play between federal laws and state laws as well. What I truly try to present here in this chapter is that the doctrine of preemption has been abused and misused in the past, particularly in the areas of climate mitigation. I discuss a lot efforts to restrict fracking and some of the state level preemption fights that have come into play in that policy area. And so what I argue in this chapter is that preemption is a very important tool. It will be necessary to get climate adaptation correct, but we need to get it right. And we need to not repeat the mistakes of the past so that we're using preemption when needed, but otherwise giving local communities and local governments the authority to develop truly local solutions that take into account their unique particular circumstances.
You mentioned that preemption has been used to strike down climate mitigation or adaptation laws in the past. Could you give us any examples that come to mind?
Yeah, so I mentioned before, but primary example for me is the fight over local regulation of fracking. I have actually worked on this in my role in the Environmental Law Clinic at the University of Denver. This is one example of continuing disputes. Exclusionary and restrictive zoning are another big example, but there have even been preemption fights over things like building codes, such as should new construction be investing in outdated fossil fuel infrastructure, such as natural gas lines and hookups in new buildings, or should there be restrictions on water use and the installation of grass lawns in places like Denver and other parts of the arid West where there isn't enough water to feed, Kentucky bluegrass that there might be in eastern states. So at the state level, there's a few different ways that preemption has been recognized. The first of those is express preemption, where a state law will explicitly say that local governments cannot regulate in a certain area or perhaps enact a particular policy. A second area of preemption is that courts have developed a doctrine of implied preemption. The idea here is they conclude that state regulation in a particular area is so comprehensive that it leaves no room for local regulation on that topic, and especially in a way that might vary from the state level regulatory scheme. And then a third type of preemption that has been recognized is that even when the state regulation is not so comprehensive as to occupy the field, and when the state hasn't even said anything one way or the other on whether local government has authority, sometimes courts will still find conflicts on a case-by-case basis. And the idea is they will find some conflict between a state and local regulation, and say that the state law prevails and the local law cannot be given effect. Now, this makes a certain amount of sense, especially where it's not actually possible to comply with both the state and the local law. Perhaps one requires you to do one thing and the other requires you to do the opposite. However, what I've observed in practice is that courts have extended this idea of conflict preemption to say things like a local government cannot prohibit something that is allowed under state law. And to me, that is really just kind of silly and misguided. And I would group this in with the whole idea of field preemption or implied preemption. But other forms of preemption, such as express preemption, where a state actually explicitly considers the issue, states that it wants to preempt local laws, and even a more limited version of conflict preemption, such as where it's not possible to comply with both sets of laws. I think those make good sense, and they're important tools for both state legislatures and courts to ensure some rationality between the different legal requirements at the state and local level.
Thank you for expanding more on that. And just like the question I asked Sarah, how or where did you get the idea for this chapter? And how does it relate to your current or prior work outside of this book?
Yeah, so I got this idea based on my work representing clients through the Environmental Law Clinic at the University of Denver. So a little over a decade ago, we started to see a lot of conflicts here in Colorado as the developments in fracking technology led to the latest boom in oil and gas development. And in particular, what we saw here was that it allowed industry to go back to previous areas that they thought had been fully exploited. They'd been drilled before and oil and gas was extracted, and then they'd moved on. But fracking allowed them to go back and access additional oil and gas reserve. In the meantime, there had been a lot of explosive population growth in Denver and the surrounding cities and suburbs. And so this new fracking development was occurring literally in people's backyards or perhaps behind their school or near churches and other places where people congregate. So if you combine that with the new location and conflict with other land use, but also the increased size and the industrial scale of modern fracking operations, it created a lot of conflict between drillers and everyday people going about their lives. So what really happened was several local governments here in Colorado, or the people themselves, took these matters into their own hands. I dedicated my chapter to Kay Fissinger, who was one of my clients with the group Our Health, Our Future, Our Longmont. And after the city of Longmont failed to respond aggressively enough to the threats of neighborhood drilling in their community, Our Longmont organized a ballot measure to ban fracking within the city. They got this to pass with strong bipartisan support in the community. But what immediately happened was the oil and gas industry and even state regulators sued the city of Longmont on preemption grounds. Ultimately, the Colorado Supreme Court ended up rushing to the oil and gas industry's defense and found that that local ban on fracking was preempted. And it did so based on that idea of conflict preemption that I was discussing before, but it did it in a way that was really tortured, in my view, in order to block local regulation of fracking. The court actually ruled that the state had an interest in fracking, even though state law never mentioned the term fracking and had only the most minimal regulations in this area. But the court said local governments can't prohibit fracking because the state has a strong interest in it.
Wow, that's a really interesting case study and definitely illustrates what you're saying. And I guess one of the mistakes of the past that you alluded to before. So now looking forward, can you tell us a little bit more about some of the previous or ongoing efforts to change preemption law? And maybe what are some of the most promising opportunities for change moving forward?
Yeah, so I will say I'm not super optimistic that the courts are the best area for change. I've seen examples time and again, even if you have so-called blue states or courts with judges that are appointed by Democratic legislatures, those state courts are very highly deferential to powerful industries. A big example being the oil and gas industry. So what I've seen is that courts will likely need to be forced to change, either by the people or by the representatives in the state legislature. So I think those areas are much better. One contrast that I explain in the chapter is that at the same time we were losing our preemption fight in Colorado, similar efforts in other states were succeeding, and Pennsylvania was the notable example. What was different about Pennsylvania? Well, they have a state environmental rights amendment in their state constitution, and the courts there relied on that provision to avoid finding preemption of local restrictions on fracking. At the same time in Colorado, where the courts found that the state had an interest in fracking and local governments could not interfere with that. So this really highlighted for me the way that unique state laws could impact the preemption analysis and lead to potentially better outcomes. So I think those lessons from some of the failures in the fight of climate mitigation context can give us a roadmap for how to do better on climate adaptation issues going forward. The other thing I would flag is that the legislature has a lot of power here too. They can and should be able to explicitly preempt certain climate adaptation policies that are counterproductive. So Sarah mentioned in her chapter some of the psychological reasons why communities might want to continue rebuilding in areas that are highly likely to flood, for example. That might be an area where legislatures could step in and say, you need to stop this. We need to consider moving to a safer area that's less likely to suffer disasters going forward. The legislature can also attempt to rein in these state courts that have, in my view, gone rogue and are just in the pocket of industry. And they could do this by enacting laws that emphasize that there should be a presumption against preemption, meaning you should default to allowing local regulations in an area. And they could even say that state courts should be discouraged or even forbidden from finding these implied or conflict preemption rulings, which have really stretched the doctrine beyond their original purpose, in my view.
I am curious about that one success story in Pennsylvania. You mentioned it was a state environmental rights amendment. Is Pennsylvania the only state with a similar environmental rights amendment?
There's several that have some. So another notable example, I would say, is Montana. There was some recent high-profile litigation about children's rights challenging special exemptions for the fossil fuel industry from their environmental laws. And so we saw another, I thought, very good decision out of that state. There's a number of states that have similar provisions, but there's been kind of spotty application of those. But I do think it's a promising area and that other states should consider emulating, adopting, or even strengthening provisions in their own state constitutions.
Yeah, that is really interesting. It's interesting to think that some states could be leading the charge and providing that sort of model for other states to follow.
Yeah. In Colorado, we don't have an environmental rights amendment. There have been some attempts to get one on the ballot, but we don't have one so far. But what we ended up seeing was the situation with neighborhood drilling in our communities got so out of control. We actually had a lot of really unfortunate accidents. Some people died. There were explosions, some high-profile stories of giant oil wells being put in literally hundreds of feet from school playgrounds. And eventually, the legislature did spring into action. And they stepped in, updated their oil and gas laws. And what they did was explicitly carve out areas where local governments could regulate the industry. And so that gave me hope that even in states that have a bad legal framework or where courts have been rushing to the defense of the oil and gas industry, you can still see the legislature step in and preserve that important local authority to regulate some of the worst impacts here.
Absolutely. And I think that leads straight into my next question, which is that your chapter advocates for striking that important balance between granting states the power of preemption to stop those local policies that might inhibit adaptation. I think you mentioned as an example, looking back to Sarah's chapter, maybe in a community that's particularly vulnerable, not encouraging more and more building in a floodplain, but also ensuring that the bar is high enough that positive local policies or self-directed policies can continue without being stricken down. I'd love to hear more about that careful balance.
Thanks for that question. So I just want to be clear. I know I've been pretty negative about preemption law and the way it has been used in the past, but I don't think preemption law is all bad. It's an important tool that can help resolve some of these conflicts or prevent local governments that are taking kind of truly counterproductive efforts. So yeah, we discussed earlier how Sarah had noted in her article some of those psychological factors that make it hard for communities to accept loss, and maybe they need a nudge from preemption law and people with a broader perspective than just that community, but maybe at the state or even national level to help them there. I guess another example might be those climate havens that we've been talking about. If there are climate havens that are resistant to people moving into their community, perhaps they employ restrictive zoning tools to try to limit new housing growth and try to keep people out of their communities. That might be another area where preemption could be needed to overcome some of those barriers. So I think it's important. So I just want to be clear that the states and even the federal government appropriately have the ability to prevent wasteful spending of resources or to prevent adaptations that are going to be critical to adjust to our new climate change reality. But at the same time, as I think I've made clear, preemption can be easily abused. So we've seen repeatedly the fossil fuel industry run to the courts to block local restrictions. And even if they've already perhaps lost a battle at the state legislature, they can still go to the courts and try to block whatever is happening at the local level. So I think it's critical that courts be reined in a bit and that legislatures and even the people themselves, where they have the ability to adopt ballot measures to their state constitution or state laws, even local charters, can be a really critical way to empower local communities to develop the tools that they need to plan for climate change as it comes down.
Definitely. You mentioned federal preemption too, and your chapter is mostly focused on state preemption, but where does federal law fit into this equation when we consider that other power of federal law to preempt state law? And after all of that is said and done, what remaining power is there for local governments?
I think that's an important question, looking at federal preemption as well. I really focused on state level preemption and the dynamic between state and local authority, but there's the same dynamic between federal and state law. One thing I'll emphasize is that local governments derive their authority from state governments. So if federal law or the federal government preempts state action, it's also going to preempt local action. So this can still come into play here. And certainly that leaves plenty of room for mischief. If federal judges or Congress or a particular administration is opposed to climate adaptation or wants to pretend climate change is not an issue, they can cause a lot of problems. And my proposals on preemption are not going to change that. We really need government leaders with good judgment and judges exercising similar good judgment if we want to get this right. And if we don't have that, that's going to be a problem. And I can't fix that with my solution here. But I will share that there are some encouraging efforts in this area. There have been a lot of lawsuits brought recently where local governments have been trying to sue under nuisance law against the fossil fuel industry. In Colorado, we have an example where the city of Boulder is suing Exxon, and then Suncor, which is a Canadian company that operates an oil refinery here in the Denver area. The theory is that these companies have known about the impacts of the climate pollution that they have emitted in the state and what the impacts would be on those local communities, such as Boulder, and the environment for their citizens. But you've seen a lot of these as well in other states. There's a case out of Honolulu in Hawaii. There's a case out of Baltimore. So currently, our state Supreme Court in Colorado had oral argument, and we're waiting for them to issue a decision on the question of whether the Federal Clean Air Act or perhaps federal common law somehow preempts these state nuisance law claims. Now, this seems crazy to me, but it would be a form of implied or field preemption that courts have kind of fallen for in the past and some of their, I view, mistaken extensions of preemption law. But there was some good news out of Hawaii. The state Supreme Court there issued a really good decision finding no preemption on a similar case brought by Honolulu. The industry rushed to the U.S. Supreme Court where they thought they'd have a more friendly reception. And fortunately, the Supreme Court turned away that attempt and refused to overturn Hawaii's decision. So I'm hoping we'll get a similar ruling in Colorado, although given our past history, I'm not really holding my breath.
Sarah, just like I asked Kevin, do you observe any connections between this preemption chapter and the one that you wrote?
Well, yeah, I think the biggest connection is that any conversation about authority at the local level has to take into account that basic level of authority at the state level, but also the very real prospect of preemption in a lot of parts of the country. And so it would be very incomplete to have that conversation about local governments without having that conversation about preemption. I think Kevin does a great job of highlighting the good and bad nature of preemption. I think that makes sense because it's just a tool like any other tool to achieve policy outcomes. And so sometimes that might mean that local governments need the authority to adapt in various ways and account for those changes. And sometimes that might mean, as Kevin already noted, that the state needs to jump in. And one example that I don't think has really come up is this question of renewable siting. It has a lot of similarities to fracking siting, but a very different kind of policy valence. And there's been a lot of conversation about should states prevent local governments from keeping out renewables projects from their communities. And so Illinois, for instance, a couple of years ago, passed a pretty preemptive law at the state level, taking away authority from county level governments in Illinois from imposing lots of pretty restrictive requirements for renewables coming into their communities, whether it's turbine length or overall solar area that can be occupied. And so county levels had that authority taken away from them in a variety of ways in Illinois now. I see a lot of pushback on that in terms of people saying, well, can you say that local governments need authority on the one hand and then say, well, it's okay for states to take that authority away in other contexts? And I think it just does all come down to what is the overall policy change that we're working toward here, which I think is addressing these high levels of warming.
I appreciate you drawing those connections, Sarah. So, Kevin, before we wrap up, we've touched on this a little bit, but at the end of the day, how can state courts get this right?
If we have good leaders and we have conscientious judges, and particularly if they're supported by the people, And by pressure in the political realms, then we can make progress on these challenges and we can come out stronger on the other side. So, what I think is that organizing and engaging by individuals can be really critical to success here. And that's something we can all do. So, I think that's important at a time when it can be easy to feel hopeless in the face of everything that's going on. If we keep up the pressure at our local level, and that can contribute to pressure at the state level that can influence our legislatures and judges to do the right thing here and enable us to adapt to the high level warming that is coming our way.
Right. Thanks for that insight, Kevin. That's a very positive note to end on. Let's come back to Katie and Shannon. After hearing about these two wonderful chapters, I'd love to hear more about some of the other chapters featured in the book.
Well, I might start with an interesting observation about the other three chapters in this section. The other three focus on questions of framing in environmental governance and law. Kevin and Sarah talked about the importance of the policies driving the governance. Preemption isn't necessarily bad or good. We're thinking about how it functions in the context of high-level warming and whether it limits local government's ability to use tools to adapt to climate change and to mitigate climate change. This kind of legal and policy change occurs in the political realm and is responsive to policy framing. And so Melissa Powers' chapter on Texas's policy rhetoric following Winter Storm Uri illustrates the power of political rhetoric after an event where climate change might be part of the policy discussion. And as she explains, the rhetoric didn't always match the real causes of the energy system breakdown. The two chapters that follow talk a little bit about this too, The Tyranny of Baselines and Josh Galprin's chapter on environmental framing around the balance of nature. A lot of our laws are built on this notion that nature is static, a snapshot in time, and we want to preserve it. We know that's not the way nature functions or ecosystems work. We know that's especially true with the disruption of climate change. And so there's tension sometimes between our laws and our policies and the reality on the ground. And those chapters do a really good job of illustrating that tension and offering some thoughts about how we might build flexibility into governance structures and how we might respond to those realities.
Sarah, in preparing for today and going back and taking a look at the chapters, I was struck by how salient they are today. So Shannon talked about Melissa Powers' chapter on narratives after Winter Storm Uri, where the power outages were quickly blamed on renewable energy sources. To my mind, that connected up immediately with the competing narratives about responsibility and causes for devastation in California from the wildfires. And then also related to Professor David Takasha's chapter on the climate change biodiversity nexus, because one of the narratives that we saw come up immediately after the California wildfires was this idea that these fires, or our inability to control them, was exacerbated by a lack of water because too much water is being taken to protect endangered species in California. We need to take all that water away from endangered species and send it down for firefighting, which is a beautiful illustration of both Professor Powers' point about the importance of defining and shaping narratives as we deal with climate impacts, and then also Professor Takasha's point about how when we think about trying to protect biodiversity in the face of high-level warming, the decisions we make about how we mitigate and adapt will have direct impacts on biodiversity.
So, is there anything else you all learned from editing this book or writing a chapter or reading through others' contributions that will inform your work moving forward?
I want to share something I'm so excited about. And I think all the law professors on the call may appreciate this. Sometimes you write something like this, and especially if it's a book chapter, and you just kind of think, oh, maybe it's just going to sit there. It's never going to be useful. I literally just read a portion of my chapter into a public comment process on draft regulations in New York earlier this week. And I was so excited that it had modern day salience. And so the backdrop is my chapter in the book focuses on avoiding what I call performative climate justice. So thinking about as we adopt climate laws, there's a lot of rhetoric about making sure our transition is a just transition, et cetera. But how can we structure the laws to protect justice in real ways? And something I point out in the chapter is that when New York State adopted laws to expedite siting and environmental review for the construction of large-scale industrial renewable energy facilities, so wind and solar arrays. One thing that they did is that they significantly cut back on the protections for environmental justice review, both as a process and then as a matter of judicial review. And in talking about that in the chapter, I say, okay, I understand why we might not think that this is a context in which that's much of a trade-off, because traditional environmental justice communities tend not to be located in geographic areas where you can physically fit a solar array or physically fit a wind farm. So maybe that trade-off is okay. But I explicitly said one of my concerns here is by not acknowledging the justice trade-off, we might create the risk that New York State could cut and paste this same expedited siting and review approach into other contexts for other climate and adaptation policies that have more concerning negative local impacts. And sure enough, the Office of Renewable Energy Siting in New York has copy and pasted the same expedited environmental review process from the process for physically locating wind and solar arrays, and now is going to use it for transmission as well. And transmission are the big, long power lines, which we know from experience, there will be incredible pressure for those power lines to run through the poorest, most disadvantaged communities. And so I was able to go back to the chapter and talk about the need to at least raise the possibility that in the context of transmission siting, we might not want to make the same trade-off with respect to the protections that are needed to prevent aggregation of transmission infrastructure in environmental justice community.
I could just add there, maybe on a similar vein. I mentioned earlier the case that the Colorado Supreme Court is currently hearing about a preemption challenge to state nuisance litigation. And I was really excited this past fall because several of my students got to work on that case and submitted an amicus brief making arguments about why preemption shouldn't apply there. And what it really reminded me, and I think key for the book, is that there's a lot of work ahead for lawyers to get this right in the climate adaptation context. And so I really value teaching in the clinical setting and helping training the next generation of lawyers to take on these challenges. I was able to draw on some of the insights that we've developed in thinking, developing, and writing this book to use in that litigation and to train future lawyers here.
I think Katie and Kevin are illustrating precisely what I hoped would come from this book, which is that we would all focus on the ground on issues of climate adaptation. For a long time, for very good reasons, environmental law professors were very focused on climate mitigation. We still are, but we know we have to adapt. And I'm especially proud of chapters like Katie's in our equity and justice section, because we're going through a period where maybe at the federal level and in some states, we're rolling back explicit protections and approaches to incorporating equity and justice into our governance systems with respect to climate adaptation. And as these chapters illustrate, even if we do that, these issues exist. We will have to grapple with them. And I'm very glad that so many authors took the time to focus there. And I hope that helps continue this conversation at various levels of governance.
Yeah, I value most the interconnectivity of all of the issues that we're talking about, and just how clear it is that high-level warming is going to require all of us to take this on from a number of different valences and viewpoints. And it's somewhat bleak looking at the science, but to me, at least, it is a helpful way of breaking it down and saying, here are all the things that we could and should be doing now to at least prepare ourselves a little bit better. And that way, I do think it's just really useful and was really generative for me to be part of.
I will add, Dara, something that I am proud of looking back at the book is that our wonderful editors at ELI really encouraged us to go back through the chapters, and any place where one chapter was talking about something that was discussed in another chapter to insert an explicit cross-reference. And having done that, it made me realize there are so many ways in which the chapters are in conversation. And I think that is partly a product of the fact of the unusual process that we use to develop the book. I'm grateful to ELI for encouraging us to do that. I think it makes the book stronger, and I think shows a way in which it's a little bit different than a traditional academic volume.
Absolutely. And I think that approach definitely shines through, and it's a really helpful one. So if listeners want to follow up on some of these chapters, where can they find this book?
The URL is a little too long to read out loud, but if you go onto Google and you type in ELI, Adapting to High-Level Warming, your first result should be to the Environmental Law Institute website, where you can purchase a copy of the book directly from the Environmental Law Institute.
Well, thank you all so much for coming onto the podcast. It was wonderful to learn more about the book and the chapters. And I'm really looking forward for our listeners to get to read this wonderful book for themselves too.
Thank you so much. Absolute pleasure to talk with you and also have a chance to reunite with some of my colleagues in the Environmental Law Collaborative.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.